And one. Well, hello and welcome to this very special BCSD Australia event, series, where we're calling out a very important question that has arisen as a result of a very important case that has come about, not in Australia, but overseas. And with that, we're going to delve into what it means, certainly get some insights from somebody who's deeply involved in the case, and I'll get him to talk to you about that in just a moment. But also, well, what does it mean for Australia? Because these ripple effects in every stage and phase of our life at the moment can't help but ask questions about what does it mean, I guess, personally, but also professionally and certainly corporately. So welcome, and in opening, let me acknowledge the traditional owners of the land from which I'm joining you today and pay my respects to elders past, present and emerging. I'm coming to you from the land of the Camaragal people. So as I said, today's session is designed very much to have a breakout from our usual cadence of the landscape session to talk about SB13, and I will let our guest speaker talk about what that stands for. But the question is, well, what does SB13 mean in plain terms for Australian business, and then test what, if anything, does this case actually mean that happened in Texas only a few weeks ago. To be clear, this is not a political discussion. It is very much a business and a legal discussion, and we're very interested in the legal reasoning, the commercial implications, and obviously the practical lessons for boards, for executives and advisors. For those of you who may be new to what SB13 is, it's a Texas law passed in 2021, which in simple terms was designed to push back against financial institutions seen by the state as discriminating against fossil fuel or energy companies. I'll let our guest speaker give some more detail into that. But most importantly, in February of this year, a federal judge in Texas held that SB13 was unconstitutional, and it blocked enforcement, finding problems under the First Amendment, and we know that very well in Australia as to what that means, but also the 14th Amendment, which I had to look up, including that the law was overly broad and impermissibly, I love that word, vague. Now, these matters tell us something important, I think, and that is, even when governments want to take a strong policy statement, there are still legal limits on the books of how broadly they can frame and enforce those kinds of restrictions. So today, we're very unfortunate to have with us David Levine, or Levine, my apologies, David, who is the co-founder and president of the American Sustainable Business Network. Sounds familiar? Who has been very close to this issue in the United States. And also welcome Ilona Millar, partner of Gilbert and Tobin, who's going to help us think through the wider legal complications, legal and commercial complications and implications for those in Australia. Please use the Zoom Q&A function if you do have a question, and we'll curate just in a few minutes just before the end of the hour. And we'll hold hopefully a dedicated audience session in that part of it. But firstly to David, let me welcome you virtually to Australia. And let's start with the fundamentals. David, tell us a quick bit about yourself and a quick bit about the American Sustainable Business Network.
Great. Well, it's a pleasure to be with you, at least virtually. And right, I am the co-founder and sit as the president of the American Sustainable Business Network. We have two organizations in there, one which is the educational, or what we call in the US the 501c3, and one the advocacy, which is the 501c4. And we are a network of business organizations, companies, investors, business leaders that collectively, through all the organizational members and our direct business members, represent over 200,000. And our mission is to inform, connect, mobilize, and amplify the collective voice of sustainable business, and to engage and transform the public and private sectors towards a more just and regenerative economy. So our strategy, we use research, narrative shift work, create the business and economic case. We do the amplification in the media. We mobilize investors to shift capital. We do issue advocacy, and we do public policy engagement at the state and at the federal level. So, so for us, this, was an interesting opportunity that
Okay.
emerged. So,
Oh,
for us, the simple piece of it though is we just really believe that at this point in history, and certainly throughout our founding, that it's important for businesses, A, to work together, B is to stand up and speak out for what we believe is the right path forward for business and the economy.
okay. So let's go to the case itself. And up front, the network itself was one of the plaintiffs or the applicants in the proceedings, was it not?
Right. So the American Sustainable Business Council, RC4, was the plaintiff and the like. And through that, we were representing two of our members, Etho Capital and Sphere, which are two investment firms that were blacklisted under the Senate Bill 13. And we were represented by Democracy Forward in particular, and then Council on the Ground in Texas as well. And Democracy Forward is one of the legal organizations that's filed a lot of the lawsuits challenging the administration at the federal level.
Okay. And so, just to make it concrete for our audience, this was not just a disclosure standard or a voluntary code. This was, in fact, the state of Texas saying that if a financial firm was seen as limiting commercial relations with fossil fuel business, then that firm could actually face exclusion from public
Right.
money, public contracts. Is that the right way to understand the practical
Right.
effect of
So it was,
the
yeah.
law?
So we saw it as an anti-business law. It barred the state pension plans and the state's permanent school fund from investing in, and then required them to divest from financial institutions that quote unquote boycott fossil fuels. And that was particularly vague, right, when they said that and wrote that into the law. And so the SB13 in Texas was the first boycott fossil fuels law of its kind in the US as well. And so it required the state controller to create this blacklist of financial companies that he determined, again, boycotting fossil fuels. And it also barred public contracting at the state and local level with companies that, again, boycotted fossil fuel companies. And
Okay. So then let's get to the decision. And if you were explaining it to your members and let's say an Australian board, a corporate board, um, in a minute, what would you say was the most important parts of the court's reasoning?
well, as you mentioned, we sued because we believed that the bill was unconstitutional and bad for business. And so the court before them was to really look at, at what we stated, that it was written so broadly that it infringed on protected speech, and whether it was vaguely written that the regulated parties, the financial companies, the businesses, would not know how to avoid being blacklisted or considered as fossil fuel boycotters. And so the ruling in their favor was they did find it unconstitutional on the First and 14th Amendment. They struck it down, and it was as the first decision of its kind from a federal court, granting a summary judgment in ASBC versus Hagar. And Ms. Miller could certainly talk about what a summary judgment is, what all these different aspects are later on down the line. I am not the lawyer here. Um, and
Probably a good thing.
so it just facially violated the First Amendment because it was overly broad. The law's definition of boycotting permitted the state to penalize businesses based on their what we believe is their protected right of expression. And
Mm,
it, as you mentioned, it was also unconstitutionally vague in violation of the 14th Amendment, right? The due process clause, right? It was
right.
so vaguely written
Yes.
that businesses were unable to know from the text whether they would be considered as boycotters, and once they were on the list, how they could get off the list. And just on those grounds as well, that's what the courts were really ruling on.
Okay.
So they
So
weren't ruling on whether fossil fuels were good, whether
no.
renewables were good. It was
Yeah.
really on what we said. is our right. And certainly we know in the United States we have Citizens United that were giving corporations all sorts of rights and the like. But here was our right to for speech, right?
Mm.
And and the irony we also saw in this was that a good deal of the federal administration in a number of states like Texas have been rallying against regulations of all sorts. Government shouldn't tell business what to do. And here you go. They were surely telling business what to do and not to do through this particular case.
Case, yeah. So, in bringing the audience up to date, the case is being appealed by the Texas state, but in turn, as David just explained to me, the network or the council is actually appealing that appeal. So interesting. We'll
Right.
get to Ilona in just a
So
second about what that
for
all
Ilona,
means.
the way what we filed was the plaintiff's opposition to the state defendant's opposed motion to stay pending appeal. Ilona,
Right.
you take that one.
Very, very clear. But before we jump to talk to Ilona, the question I wanted to ask you, David, was there is a real risk in these kind of high-profile cases that people will immediately overread them. So, where do you think this ruling creates clarity, and where does it still leaves uncertainty, at least in the United States?
Well, look, I think one of the things that we argued was that this has a negative impact upon the economy. You know, the law, from what we've understood, has cost the state nearly $700 million in lost economic activity and 3,000 lost full-time jobs. And this is according to the Texas Association of Businesses, right? So this is not a progressive, it's not a sustainability organization. It just, and it caused $270 million in increased costs for banking and financial services. So straight up, these restrictions had a serious implication for the economy, for jobs overall, for business, for the financial institutions, et cetera. So, when we look at these cases and take it out of the politics and the rhetoric of, anti-ESG, woke, et cetera, and the like, the question is, and that we try to continue to argue through every issue we take on, is what's in the best interests of the economy, business, and the country. And this law and these kinds of laws are clearly not in the best interest.
Okay, so there's a good segue to bring Ilona in and welcome. Ilona, from your perspective, and certainly you as a seasoned and professional lawyer in this space, do you think we should read this decision as a fairly narrow US constitutional case about one Texas statute? Or do you think it sits within a broader pattern we should be watching in climate and sustainability related litigation?
Andrew, good morning, and good morning to everyone on the call. My perspective on this is a bit mixed. I think on one hand, it is a very distinctly US constitutional, decision, which, we don't have the same sort of framing or approach to the way that we look at, you know, climate and investment in the Australian context, but it does sit within what I would call a sort of a broader pattern of legal and constitutional challenges to laws around the world that either compel or constrain ESG related conduct. What we see is, globally, I guess at a global level, a fragmentation in terms of the way in which different jurisdictions are approaching climate and sustainability governance. We have, on the one hand, the EU, the UK, Australia, parts of Asia, all looking at embedding ESG through mandatory disclosure and fiduciary expectations. But then in the US, where we're seeing much more of a resistance and a pushback on ESG regulation, whether that's at a federal level through the approach that the SEC is taking to disclosure, or through this proliferation of laws that are essentially trying to limit the approach to investors who are focusing on woke ESG sustainable investments. And I think to some extent that sort of points more to, not to I guess a regulatory divergence and politicization of ESG, which we've seen over the last 2 years. And I think from a litigation perspective, the type of litigation is quite narrow, but the implications in terms of that divergence and approach to regulation of ESG is has wider implications.
Okay. Let's now narrow that down and talk about the practical implications of this particular decision. And I'll start with Ilona and come back to David. But in framing this part of it, you've got the reality that in Australia there's been commentary suggesting that because of the global ESG and DEI pullbacks, the Australian business itself would need to adjust. Do you think this case I was going to say perverts, wrong. It converts, changes this kind of view, or does it actually show, as you just said, that because of this that fragmentation that's going on in key jurisdictions, that the picture is much more complicated for business than even the headlines suggest? And I'll go back to Ilona and then I'll ask David.
Look, I think it is much more complicated. Decisions like this in the US do have a broader implication for Australian businesses, particularly those that are, funds or, engaging in capital markets in the US, because, there is a risk where laws like this are on the statute books that, an Australian or a global fund that has, connections to Australia could be put on one of those blacklists, and that sort of obviously has significant implications to the extent that those lists are upheld. I think then in terms of that broader question around that pullback narrative, I think one of the things that I've found really important in the judgment was this concept of, what is ordinary business practice? What is, where are investments being done because they're the right investments to make, as opposed to being done for other purposes linked to wanting to promote climate and ESG. The two are not mutually exclusive. And as we know, the decision to invest in certain companies, regardless of whether they're fossil fuel or renewable energy or energy transition, is a business judgment and decision that needs to be taken having regard to what's in the best interests of the company. And directors, when they're, making, framing the way in which a company is governed and looking at the strategy and addressing risk for a company or a fund, need to take these things into consideration. And climate risk is a real risk, as we've seen through a number of the legal opinions that have been issued here and in other, particularly Commonwealth jurisdictions, which make it very clear that directors have a duty to take into account these matters when considering risk. And if the right business decision is to invest or not invest in a particular sector, that should be what guides the investment decision.
Yeah, so David, just over to you, that complication of what to advise a company and picking up on Ilona's point around the business judgment rule that exists in Australia, that, correct me if I'm wrong, Ilona, doesn't technically exist in the United States. There is a different regime in relation to that. But what are you seeing business react to as a result of the decision in the United States? Is it one of the floodgates have returned and we can think more broadly and deeply, or are we still stymied by the politics that is bearing down on the decision that will still have an impact going forward? And you're on mute.
Just to reinforce what Ilona said, it was important to note that what the case is about and not about, right?
Yeah.
And what the court said and didn't say. Texas can choose to invest or contract with whatever companies that it would think is in their best interest. subject to whatever laws governing fiduciary responsibilities, procurement, etc. But what Texas cannot do is punish people or businesses for their anti-fossil fuel expression or their leanings towards renewables and clean energy and the like. So look, I think that the case, it caught massive coverage around the world and the like. And so for that alone, just raising this issue was really important, and challenging it on these grounds was really important, and demonstrating also what we believe is crucial at this moment, which are businesses that really hold these values to be able to speak up and take positions and let those be known, and to not backtrack and the like. Clearly those companies that were going along for the ride and kind of greenwashing, those companies bailed right away, right? And this case, is just a subset, though, of what we've seen come down from the federal administration, and the concerns and fears of companies of speaking out and taking positions. We do, for clarity's sake, we do represent predominantly small and medium enterprises.
Yeah.
And they have been willing to stand up and speak out and take these positions, and and really stand up for their values at the moment. So I think, it's indicative that there are a lot of companies that are still holding strong in their positions about their investments, about their positions, but they're not publicly talking about it, or they're changing their websites or the like. But this is not a direct result or not of the Texas lawsuit. It's really about the implications and the concerns that might come from the president and the administration itself. So what we're hoping to continue to demonstrate is, taking these values-based decisions in terms of what is in the best interest of business and the economy, make that strong business case, and hope that others will come along and join in standing up for what's right, and then eventually be able to sort of move the policies to align with the practices that we understand are in the best interest of the economy.
Okay, thank you for that. Interesting. And what was rolling around in my head then was, so is the message here that there is freedom to choose? And this is what this conversation is all about. It's freedom to choose rather than necessarily a constraint on the ability of corporates to make decisions in the fiduciary interests of shareholders, and if they do embrace a social license to operate, then the broader stakeholder community. I want to jump to questions, and we don't really have that much time, but I will go to the one. There it is. If you were advising a company tomorrow morning, what's the first thing you would ask them to review? I'll go to Ilona first, and then I'll go to David. And you're on mute.
Sorry about that. So in terms of, what boards should be thinking about, ultimately, you've got to make sure that how you're approaching, these ESG considerations are being clearly linked to your financial risk, your strategy, and maintaining the long-term enterprise value of the organization. And so the first thing to think about is, what is it that you are putting forward into the marketplace in terms of the ESG linked products or services that you're looking at, and what is the foundation for that? Where decisions are being made in that context of managing risk, pursuing a particular strategy, and building value, then I think boards are, very well, have a very defensible practice. But, if you're just using these sort of concepts for marketing purposes and the like, what we've seen in the litigation against greenwashing is that that's just not going to cut it. So I think, really look at what is the basis upon which you're doing this, and then also look at, importantly, how you are then conveying that, and what's the, what do you have to sort of link that back to the board's decision about a particular strategy it's pursuing or risk that it's looking to manage.
So we go across the ditch and, well, quite a wide ditch, back to America and ask David the same question. So you probably actually gave this answer to your constituency the day after the court ruling. But what is it that companies should do, the first thing, as a result of this decision? What are you suggesting that they should start looking at?
Well, I think Ilona really did cover it, is they're really examining what's in the best fiduciary interest, of their company. What are the values that the company actually holds, and, are they meeting, the goals? And clearly, what we've seen certainly around the globe, right, is a, larger number of individuals, customers and the like that understand the, what positions and the concerns they have about companies, corporations and the like, and the positions that they're taking or not taking and the like. So considering what, besides the shareholders, it's the other stakeholders that matter as well. Their employees. We've seen a number of companies where employees have just really pushed the company to take a different position than they were standing for and the like as well. So it's a very complicated, environment in which to be able to operate. And so going back to what's in the, the best interest, of the company and what it is aligned and how it aligns with the overall mission and values and the like, I think matters a lot. And what's going to make money? What's going to make money alongside that?
I like the way you've ended that. Okay, so thank you so much to David for coming to us all the way from America this morning, our time, afternoon, evening, your time. Thank you so much to Ilona for jumping onto this conversation and contributing, I think, really important insights into the Australian reflection. And thank you all for joining us today. If I was to reduce what I've heard and the discussion to, 3 points, I'd probably go first. SB13 was very much a Texas law that turned anti-ESG politics into real commercial consequences through the conversation of state investment and contracting rules. Second, the court did not, and I got this message very clear from both of our experts, the court did not rule on ESG as an idea. It did rule this particular law overreached constitutional limits. And that's an important variation, I think, to the conversation that we have in this space on quite a lot of occasions. And thirdly, that for Australian business, the sensible response is neither to dismiss or the issue or necessarily to overreact to it, but very much stay focused, as Ilona is suggesting, on strong governance, clear reasoning and disciplined business practice. Well, that's all for this morning. Thank you again for joining us. We look very much forward to you continuing this conversation in our next landscape session, which is on the 22nd of April. Yes, that's right. And stay tuned for further details of who's speaking on that occasion. But for now, as I always say when I close off, thank you so much for joining us and look forward to seeing you somewhere in the future. Bye for now.